Good evening, everybody. Tonight we're going to be dealing with the broad topic of the Bill of Rights, but we're going to get specifically into the Fourth Amendment, search and seizure, and the First Amendment in the second hour with Chris. To start things off tonight, Mark, if you would play us the video.
Okay.
We hid up in the cell window.
Wait a minute. What are you talking about?
We bugged Mr. Blake's cell.
You what?
We bugged the cell with Arnold's tape recorder. Just listen to this, Paul.
I can't listen to that.
But Paul.
Opie, I can't listen to that. I'm not permitted.
But Paul, you don't understand.
Opie, I can't listen to this. Now, I told you about eavesdropping.
But Paul, this is different.
Yes, it's worse. You overheard a conversation that was supposed to be private. Now, I can't be a party to that.
But Paul, if you just listen to this.
Opie, I can't listen.
Paul, you're erasing the tape.
That's what I mean to do. You bugged a conversation between a lawyer and his client. Now, that's violating one of the most sacred rights of privacy.
But Paul.
No buts.
But if it helps the law.
Opie, the law can't use this kind of help. Because whether a man is guilty or innocent, we have to find that out by due process of law.
Well, I love that clip. I can't help it but get some things out of Andy Griffith. If I was Opie and my dad was still there, I might say, well, what do you mean? Why isn't good police work part of due process law? These guys were guilty. I taped their conversation. They admitted their guilt. What's wrong with all of that? Why can't we use it? Well, that's what tonight is really all about. All right, so first of all, let's go into the document, Mark, on the amendments offered to Congress by Madison, June 8, 1789. All right, as we have discussed, you've got people like George Mason who leave the convention saying, I'm not signing this document. There is no Bill of Rights, all right? Prior to this, Madison actually wrote Thomas Jefferson, and Jefferson's in France at the time, and I'm paraphrasing obviously now, and he says, you know, they're giving me headaches back there. What's the deal with the Bill of Rights, the structure of the government? There's no power for the national government to do these kinds of things. If you're going to have any of this impact, it's going to be at the state level. Jefferson basically writes back and says, look, if they want a Bill of Rights, give them a Bill of Rights. So he does. He proposes this on June 8th, 1789. Now, look at, if we can glance over this quickly, make it a little bit smaller, Mark, if you can. Yeah, and then let's look, I want us to look through it. Notice that how he starts off, what he says in the beginning, he sort of repeats what we're all about. The Constitution, a declaration that all power is originally vested and consequently derived from the people. He's talking about the idea of popular sovereignty again. Then there's phrases from the Declaration of Independence. And then the third paragraph of the idea that, look, we have the right to change our government when it's found adverse or inadequate to the purpose of its institution. And then lays out some rights. Let's skip down past the first, the second, and third one for a second. Scroll down a little bit. Okay. If you look at these, you're going to notice the embryos of what our Bill of Rights looks like. They're not numbered. These are ideas at this point. They're gestating, if you will. They're growing. You can see very similar results from this in terms of what our Bill of Rights looked like. Now, go back up to the top real quick. Okay. If you look at the second and third, interestingly enough, Congress passed on 12 amendments contained in this letter. The states rejected 2 of them. So that's why we have 10 and not 12. Originally, the First Amendment was the Third Amendment. and it got moved up because these two were bumped off by the states. Interesting, what are those amendments? What do they have to do with? And you get them in the second part here and the third part here, basically saying number of representation is fixed for a congressional district would be around 40,000 people. Well, do you think that amendment will ever be passed? No, because the size of our congressional districts are now 500 to 600, maybe 700,000 people per congressional district. The third one is interesting because it wasn't passed until 1992. The idea was there, but a gentleman who, in Texas, he was a law school or in college, noticed that this amendment had not been ratified. And it was the one that suggested that people, members of Congress, could not give themselves a pay raise in their own Congress. They'd have to win an election in order to get that, be qualified for the pay raise. That was not there until 1992. So that's our 27th Amendment, all right? So within this letter, you get the ideas of what sort of then fleshed out as our Bill of Rights. All right, now, if you would go to the Fourth Amendment one page in our syllabus. Yeah, there you go, Fourth Amendment. No, Fourth Amendment, bottom one. All right, here it is. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but under probable cause, supported by oath or affirmation, and particularly describing the place to be seized, searched, and the persons and things to be seized. Okay. What do we call when somebody enters our property without our permission? Trespass, right? We're basically giving the power to government to trespass on our property, except, notice the word unreasonable. That's the qualifier. Are we protected against reasonable searches and seizures? No. We're only protected against unreasonable searches and seizures. So the whole discussion of Fourth Amendment deals with the idea of what is reasonable and what is not reasonable. Now, who decides that? Well, there's another protection here, is that you have to have a warrant that's issued by a third party in order to conduct this search and seizure on us. And it has to be based on some kind of suspicion. That's probable cause. That's not certainty, and that's not a hunch. It's something in between that. And supported by a third party being a judge. And not only that, you got to particularly describe what you're searching for and the persons. These aren't general warrants, all right? Now, let's jump back a bit because I mentioned the term general warrants. Where did that come from? All right, okay, Mark, if you would go to Otis. All right, it's important, I think, for us to discuss what happened, where were we before the Constitution? What pushed the idea of a Fourth Amendment? Well, the colonists had been living under the writs of assistance, these general warrants that were good for the life of the king. And government agents could search anywhere, anytime, any place. Well, colonists got a little bit upset about that, all right? So we make this a little bit smaller. So the merchants in Boston decided, we've had enough of this. So we're going to take it to court, all right? Now the person who's supposed to be defending the government is James Otis. He's the Advocate General when these warrants came out. Because of this, he resigned his post, and the Boston merchants hired him to argue the case. In a 5-hour speech, he delivers his argument about why this is abuse of the rights guaranteed in English common law. Interestingly enough, in the courtroom is a young John Adams, who I believe was around 26 at the time. I mean, it's sometimes hard for us to think about founders being young. But he has been, when he left the courtroom, he's acknowledged to say that then and there were the seeds of the American Revolution. Because what happened is that the court said, you don't have a case. And the response was, it appears to me the worst instrument of arbitrary power, the most destructive of English liberty, and the fundamental principles of law that ever was found in an English law book. No, now one of the most essential branches of English liberty is the freedom of one's house. This is where the famous phrase, a man's house is his castle, and whilst he is quiet, he is well guarded as a prince in his castle. This writ, it should be declared legal, would totally annihilate this privilege. He loses this case. And some might argue that, the famous question that you talk about is, what were the causes of the American Revolution? Well, I submit to you tonight that one of those major causes was the idea of living under the general warrants and the writs of assistance, which then obviously ended up with our Fourth Amendment. Okay, let's go, Mark, to Fourth Amendment cases. Okay, I'm going to go through some of these, and I may not be able to get to all of them. Let's go down to Homestead to start with. All right, you might say, well, 1928, all right, what in 1925, in the 20s, what might you do to make a little bit of extra money on the side? Well, you bootleg. Roy Homestead is in a perfect situation. He lives in Seattle, Washington. He goes up to Canada. He gets the booze, brings it back, and distributes it throughout the Northwest. And it's interesting that they did this as a sort of a mission from God. They thought the amendment that outlawed liquor was unconstitutional, and therefore they were doing God's work to supply the booze in that area. And they did it without guns. They pride themselves that they didn't have to do this sort of in a nefarious way. They were really open about it. Well, they were so open about it that the FBI decided, we're going to tap Roy Homestead's phone. We're not going to go inside his house. We're going to tap the lines outside and listen to conversations without a search warrant. Well, and remember, at this time, he's making $1 million a year. His business was making $2 million. He was getting $1 million a year doing this. A lot of money in 1925. They tap his phone. They listen to phone conversations for 6 months. And there's phone conversations about him and his girlfriend, getting into fights, making up. There's phone conversations about bootleg, all kinds of stuff. They don't tape it, but they have somebody sit there and write all these conversations down. Then they go in and they find in his business evidence of bootlegging. Take him to court. He's found guilty. He argues that this is a violation of the Fourth Amendment. They did not have, the police, the FBI did not have a search warrant to search his premises. They got the information. I mean, they had a search warrant to search his premises, but they got the information without a search warrant by using phone conversations that they recorded. The court, in a 5-4 decision, basically says, well, let's look at the Fourth Amendment. It talks about going onto somebody's property, trespassing in a sense, but doing it without a warrant, but in picking up papers and effects. The police here didn't do that. They listened to things out in the airwaves. They didn't enter, his privacy wasn't intruded on because they didn't physically go into his building. They were taking a very strict look at an interpretation of the Fourth Amendment. Now, what I think is intriguing about this case, beyond the whole facts of the case, is Justice Louis Brandeis's dissent. And I'm going to paraphrase. He basically says, what kind of technology is coming down the pike that we ought to think about in terms of privacy? The Fourth Amendment, as written, should include the invasion of privacy, not necessarily just whether or not you search somebody or not. He had been writing about privacy since the 1890s in law journals, and you can look those up and find that. So he's sort of putting in his head, because remember, you know, the $100 question always is to ask kids is, where is privacy in the Constitution? And they'll look through all that. It's not there. The word's not there. So our implications for this are in other amendments, including the Fourth, that we do have some right to privacy because we talk about that in the Fourth Amendment, although we don't use the word. All right, so this is 1928. So what happens with a new court years later? Now go down to Katz. In 1967, Katz, in this case, the court looks at something similar, except in this case, what the police did was they noticed that there was a phone booth that a lot of, quote, bad guys were using. So what did they do? Clever. They tapped the phone, hoping to hear about conversations of illegal activities. You know, people would come in and out, they wouldn't know it's being tapped, it's not in somebody's residence, and then you have this problem of, does the Fourth Amendment protect us against unreasonable search and seizure, require the police to obtain a search warrant in order to wiretap a public payphone? Now, it's a little bit different than Homestead, because this was a personal business phone. This is outside. We don't see phone. This one's kind of funny too, because these days, what would kids have to, you'd have to tell them what a phone booth is first to deal with this particular case. So they're tapping this public place where, does privacy exist there? Well, the court says, yes, it does. It takes Olmsted's dissent in 1928 and then uses that as a way to think through this problem in Katz in 1967. And you have the Fourth Amendment protects people, not necessarily places. Your home, yes, is protected, but so are you when you're walking down the street. You still have an amount, you know, privacy, especially in a public phone booth area. What if the police conduct a search that's unconstitutional, meaning there's no search warrant? What happens to the evidence? Well, go back upstairs to 1914. This particular case invoked what we now know is called the Exclusionary Rule. That evidence seized in violation is thrown out. Now, what does that mean? It means even though somebody is, quote, guilty, like with Opie, what he saw, they collected the evidence unlawfully because they didn't have a search warrant. Opie didn't have a search warrant, or Andy did, and he threw it out, all right? Here's what the court's doing in 1914. Now, interestingly, because the Bill of Rights, what are the first words of the Bill of Rights? Congress shall make no law, all right? Doesn't say anything about states, it says Congress shall make no law, okay? So the court makes this up and says, because you won't find the exclusionary rule in the Constitution, and says if the police gather evidence illegally, we're going to throw it out. Can't be used. It only applies to the FBI at this point. So jump up to 61. So from 14 to 61, what the FBI do is they say, you state police, you're not restricted by the exclusionary rule. Therefore, can you gather the evidence and hand it over to us? And they do, and it's called the silver platter doctrine. We'll get around this somehow if we use state folks to help us with investigations. So this comes to head in 1961. You have Dolly Ray Mapp, and there's a knock at the door, and the police are there, and they say, "We're looking for a fugitive from justice." And she says, "Well, there's nobody here from that. By the way, do you have a search warrant?" And they say no. And so she says, "Well, you can't come in." So they leave. They come back a few hours later, knock on the door again, no answer. They break in. They find her in the hallway. They show her a piece of paper that was actually an application for a search warrant. She grabs it, stashes it, they get it back. They search her house. They go in the basement. They find a trunk. And in that trunk, and they open it up, and there's pornographic magazines. All right, this is 1961. I don't know what they would have been at that point. Maybe Sears catalogs. I don't know. Aha! Here's a crime. Possession of pornographic material. She's convicted, sentenced to a year in jail, and given a $1,000 fine. Well, this goes to the Supreme Court. And the court decides that this is over the top. And they invoke the exclusionary rule at the state level. So now you have the police under the restriction of you better have a search warrant in order to search somebody's house. If you do something unconstitutional, it's gonna get thrown out. All right. Okay. What is the problem of the exclusionary rule? What happens to guilty people? They go free. This is what people start realizing or seeing. Now we know that these guys go free because of some violation of the police. So what does the court do? It starts to chop at they make exceptions for search warrant requirement. All right. For example, I'm a police officer, and I'm seeing a guy outside a 7-Eleven or a convenience store, and he looks to me nervous, and he's pacing up in front of this thing. I think, based on my 20 years of police experience, that this guy's going to rob this 7-Eleven. Can I go and pat him down for weapons without a search warrant based on my thought about this individual? How many of you say yes? How many of you say no? Vote now. Okay, I see some disagreement in there. The answer is yes, he can. All right, this is called stop and frisk. It's come up recently that the police are abusing this power, but we grant them this power in 1967 and said, yes, you have the authority to do this without a search warrant. All right, war on crime. If in your estimation you want to stop and frisk somebody, you can since 1967. All right. I'm not saying it's the good policy. I'm not saying it's a bad. I'm saying that's what it is now. Let's go further with that. I am patting you down for weapons, and I don't feel any weapons, but I feel in your pocket there's something in there, and it's a little mushy, and I pull it out, and it's an 8-ball of cocaine. And the guy says, I know my rights. You can pat me down for weapons, but that's as far as you can go. That's nothing. That is not a bullet. It's drugs. The court says This is now called the stop and feel exception to the search warrant. So in the course of a Terry frisk, and then further going, because of the war on drugs in the 80s, Nancy Reagan just saying no, the police were given the authority to do this under their discretion, which leads to a whole other discussion of police training and the power that they have. They have this power, and it's up to them to decide the discretionary use of it. All right. And I'm not bashing cops. Cops have hard choices to make about these kinds of things. So, but how far have we gone? All right. Let's say I have a search warrant for your house, Robbie, and I see, I knock on the door and I say, I've got a search warrant for stolen TVs. All right. I come in. I notice while I'm walking through the house looking for these stolen TVs, on your coffee table, you've got a bong and marijuana sitting there. I don't have a search warrant for that, but can I arrest you for that without a search warrant? Or do I have to say, Robbie, sit tight, I'll be right back. I'm going to get a search warrant for that. Don't do anything, and I'll be right back. Do the police need a search warrant to arrest Robbie for the marijuana and bong sitting on his table, up or down? Not sure's I see some not sure's out there. The answer is yes, he can. It's called in plain view. The police do not have to avert their eyes to criminal behavior going on right in front of them. You know, and run down and find a search warrant for that. That's under their discretion, and it's been these exceptions that have come out of a reaction, it seems to me, to the exclusionary rule, which put a clamp on the police. And now here's the sort of, well, okay, this clamp is still on you. We're going to exclude evidence if it's gathered unconstitutionally. But the idea of the search warrant being a part of the Fourth Amendment has gone away in a number of places, right? What about at the airport? Forget it. You give up your right to privacy at the border. You can be searched, no problem, without a search warrant. Hot pursuit. I'm running. I'm a police officer. I run into your house, or a bad guy runs into your house, and I've got to follow them. I don't need a search warrant to go into your house. That seems like a reasonable one, right? One that relates to school is a kid came to school and he's been smoking dope before school, and the teacher smells it on him, all right? And she smells his hand. Now, she didn't touch him, which might be construed as the beginning of a search because you're touching somebody. She smelled him. The court said, you do not have an expectation of privacy in the millimeter of air that surrounds your hand. So therefore, in this case, she did not violate his Fourth Amendment right of privacy because of smelling him. All right, now, recent technology has changed the game with all of this, like it did with Homestead in 28, all right? We now have phone search cases, correct? And the ones that are current are Carpenter and Riley, both decided recently that what about data in your phone? Do you need a search warrant to get that data? And the recent cases have said yes. The court has recognized that, look, if we go search your house, we have a search warrant, we're going to need a search warrant to get into your home computer. The court's now recognizing that in a cell phone, a little phone, there's more data than any home computer, and it's enough storage to send somebody to the moon in terms of computer functioning. So it's private, and therefore search warrants are necessary for those at this day. You know, the court's basically saying, look, we don't mind you getting into the phone, but have a search warrant to do it, right? A similar case like that was a few years ago. The police get this is Kylo. The police get a tip that this guy's growing marijuana in his house from phone records and things like that. Well, they are clever. They fly over his house with some heat-seeking devices and see a lot of heat. And then, without a search warrant, they do that, and then they go in and bust them. Well, the court says, and Scalia wrote the majority opinion on this, look, get a search warrant if you want to do this kind of stuff. And he made an interesting distinction. He said, stuff that you can buy at Walmart, there may not be a privacy issue here, but what I'm getting at is that the public doesn't have access to heat-seeking machines yet, right? But if I've got binoculars and I bought at Walmart and you've got your windows open and you happen to want to vacuum in naked, you don't have a privacy right there. If I can see you with binoculars, so can the police, all right? So if it's the device is something that we don't have access to, like at this point we don't, we may in the future, satellite imagery that we can get on watching, you know, our spouse go down the street in real time. If we don't have that technology handy, then there ought to be some restriction on it in terms of searching, all right? So what about a GPS system, okay? Jones, this is a recent case. The police are clever. They are following a suspect that they think is a big-time drug dealer in DC, owns a bunch of clubs, and he goes into Kmart, and while he's there, they put a GPS system underneath his car. Wow. And now we can follow this guy around. We're going to find out all kinds of useful information in finding out whether or not this guy's a bad guy or not. Well, when this is found out and gets to court, again, no search warrant, the court says, great idea, but get a search warrant first. You know, if you want to put something on there, even a GPS in terms of where somebody's going in their private driving, is there's a restriction. It's not that you can't do it, but you get a search warrant to do it first, if you've got enough evidence to get one in that case. And so there's been this get a search warrant has come back, it seems to me, in recent years versus making exceptions to search warrants that are out there. For school teachers, the case that is still there and useful for us is TLO versus New Jersey. And in 1984, the takeaway from that case is basically what the court did was say, sure, kids, you have rights in schools. We know that from Tinker. But we're going to limit them in terms of the Fourth Amendment in schools. And how do we do that? We set up a two-pronged test and set up a new standard. What is the standard for coming into your home that the police need in order to have what kind of evidence? They need some kind of probable cause. In schools, since 1984, they only need reasonable suspicion. Now, what's the difference? Community standards vary. All I know is that probable cause is a standard up here and reasonable suspicion is down here someplace. All right. And therefore there's a limitation on the Fourth Amendment liberty of students in public schools. Why? Because they're in school. And it's basically what the court is saying is it's a different place than at home where we have probable cause as a standard, not reasonable suspicion. And so search cases today, any case that deals with search and seizure in a school setting is going to rely on a TLO as a standard. Whether or not that's correct or not, that is debatable. All right. I know I've been talking a long time here and I've got to switch gears. I'll leave you with, on this part of it is, I find the Fourth Amendment and privacy issues fascinating, and we haven't even gotten into another realm of that with another whole cases of our own personal privacy with Griswold and Roe v. Wade, another discussion, all right? But the idea of privacy is coming up in a court case in Indiana. I'm going to go see the state of Supreme Court decide the case or hear the case. In this particular situation, a woman was charged with stalking. They got her phone with a search warrant, and then they issued a search warrant for her passcode. She refused. She said no. And so they arrested her for contempt. And now she's claiming that basically this is kind of a Fifth Amendment issue, self-incrimination. I have so much stuff on my phone that if I give it to you, I'm basically self-incriminating. And I don't have to do that, according to the Fifth. Well, do you or don't you? The police in this case had a search warrant in both cases, the phone and the passcode. She refused. So the Indiana court, the appellate court, Judge Mathias wrote the opinion on that one, Tommy, said, yes, you do have privacy there, and you can claim the Fifth on this. So now the Indiana court's going to hear it. I particularly I'm going to just go out on a limb tonight and say that they're going to overturn the appellate court. And then what will happen is they'll go to the Supremes, and the Supremes will probably overturn the state of Indiana like they did in a recent case we'll get into. Okay, what I have been describing for the last 40 minutes is what happens to most of us in terms of relationship with search and seizure with the FBI, with state police, our police forces, which there are many of, all right? But there's a whole other side to this, and this is the National Security Agency and its ability to spy on Americans, all right? The spy friends that I've talked to over the years, including my father, say that 1/3 of American history is classified. And it gets out eventually. Some may never. Where we have those discussions even today. What can we let out? What don't we let out? All right. There's a different ladder or progression with the NSA versus the Fourth Amendment. It's like the Fourth Amendment almost doesn't exist in the terms of the world of the NSA. And what do I mean by NSA? That's the National Security Agency. When was the National Security Agency started? And under what administration? 52 with Truman, all right? What was it? Well, we have a problem. It's called the Soviet Union. We need to keep tabs on them. We need not only the operatives on the ground like the CIA or James Bond, but in addition to that, we need ears to listen to communications all over the world, including the Soviet Union. How do we do that? And this is a special service of the president only. It was called No Such Agency because Congress didn't even know about it. All right, it was done to spy on the Soviets. Now, here's the problem. Well, you might have a problem with that, but here's a bigger problem. What happens in the 60s, late 50s and the 60s in America? What's going on then? The Civil Rights Movement and the Vietnam War. To some in government, these were issues. We need to keep track of people. So therefore, the NSA, unbeknownst to the American public and unbeknownst to Congress, turns its ears on American citizens without search warrants, because you don't need one to spy on Putin. You do on an American citizen. They do this throughout the 60s. This comes to head after the resignation of Richard Nixon, and it comes to head in 1978 with Senator Frank Church from Utah's committee on the NSA and its spying on American citizens. And they discover all kinds of programs, one of them called Shamrock, and there's a few other that they were indeed spying on people like Dr. Martin Luther King and others, all right? Leaders in the Vietnam War protest business and the civil rights business without search warrants. And this obviously is appalling to Congress, and what they do is they create the Foreign Intelligence Surveillance Act in 1978. What does it do? It creates the FISA Court, right? Super secret court. Who gets on it is determined by the Chief Justice of the United States Supreme Court. I think they have 7-year terms. You can, actually today I was looking, I actually found who's on the court now. I thought that was a secret, but apparently it's not anymore. This court is to then allow the NSA to do its business, but they've got to get search warrants. You know, oh, by the way, it talks about that in the Fourth Amendment. You got to get search warrants. It gives them limits on all of that. You come to this special court and get the ability to, for national security reasons, spy on people. They get hammered by Congress. Some would argue that they were hammered so much or restricted so much that that's how the terrorists of 9/11 got across country, because the NSA at this point wasn't doing, quote, its job because it was following the Constitution. Wow, interesting concept here. We can't do these things you told us we can't do, and therefore these guys snuck through the nets. The person you want to read about the NSA is James Bamford. I have it on my list, James Bamford. He's written 3 books on the NSA, has probably had the most the ability to see what's going on there as most people. I'm not suggesting that these are bad people. I'm suggesting that most of them are super patriotic in the sense that they're doing what they think needs to be done. The big question is can the NSA, like the police, or unlike the police, get into our stuff without search warrants? We restricted the police, but what about the NSA? Well, 9/11 changes everything, correct? I mean, it's not trite to say that. It's certainly, in terms of this, it changed everything. And all of a sudden now you have the Patriot Act being passed by everybody in Congress except one, Russ Feingold from Wisconsin, giving more power and ability to the NSA to do, quote, its job and finding bad guys. Expands the amount of time that you can go on a search without a search warrant and then come and get one afterwards. The NSA went to the telecom companies in the early 2000s, all right, after 9/11, and they said, you know, these wires that are coming in across the underneath the oceans and coming up into your stations, and then you're sending them off to the customers. We'd like you to split those wires and send this group of wires into this room where we can't tell you where it's going, and everything else just goes on to the consumer. Most of the telecom companies said yes. Some of them said no. They split these wires, and obviously they were going into the NSA. So that meant that any communication coming in overseas, emails, phone calls, if you're talking to somebody outside the country, those communications are now being grabbed and stored by the NSA for what they would later use what they call data mining. Let's look at all this stuff. We can't listen to all this stuff. It's too much. We can't read all these emails. It's too much. But let's look for trick words that might lead us to something, all right? They're searching all of this at the same time without trying to, in a sense, say, well, we're not really violating your privacy because we don't know who you are at this point. But if we find something, we're going to use it, all right? Now, when Congress finds out about this, they go apeshit, excuse me. And they say they want to sue the telecom companies. And they go, wait a minute, One branch of the government is telling us to do this, and now this other branch is mad? You didn't know? You didn't approve this? What's going on here? Now, the problem with national security secrets is there's this lag time. You know, as I said, 1/3 of American history, I think, is probably classified. That means it's kind of hard to teach present history when we don't know what the heck's going on. And in this area, I think we're in that realm. Is we don't know for certain, and we could debate that all night, and I hope you do debate that, was that a good idea or not? Is now our government through the NSA taping not only foreign conversations, but domestic conversations, and all of our emails. And they're certainly seizing them, but are they searching them? That may be a discussion question at some point. We're not really looking at them personally and all of that, blah, blah, blah. Is this what we want to solve the problem of terrorism? Is it a giving up of our own privacy in order for this value, this to keep us safe issue alive? And is this well-founded? I think these are all questions that we ought to be talking about or discussing in terms of the NSA. Again, I think they're doing a very patriotic duty. But are they doing it within the standards that we think are what Brandeis would say in terms of privacy? Are they intruding too much, or do we actually give up for the common good, give up our privacy in order to solve this tough problem of terrorism around the world and allow for the NSA to gather that information through our emails and phone calls, which certainly can't be done by the police individually for a crime without a search warrant? Or do they, and another question that arises to me is, do they just have a blanket search warrant like the writs of assistance? You know, it's like, well, we don't need this individual search. This might not have been a bad idea, this writs of assistance, in terms of national security, whatever that is, you see. I guess as an American citizen, I'm a bit worried. As much as I think most people who work there are probably decent human beings and think they're doing the right thing. We don't have enough, and in some ways can't have a conversation about what's going on. We know from what's happened, but where are we today? And where are we going in the future with this, all right? Go back to that letter one more time after we leave tonight, and you see where Madison mentions the right to conscience here, all right? It's not in the Bill of Rights, but you could assume it is in terms of religion and so forth like that, and that's kind of close. But the right to think what I want to think without government intruding in on that. It's the scaredness of 1984. You know, are we approaching that at some point? I don't think we're there yet, that they can get into my head and find out exactly what I'm thinking. Boy, if they did, I'd be probably in some trouble. But, and should they have the right, and anybody that might be the case with, do we want government in our head? And in terms of this new case that's coming up in Indiana, is the phone the closest thing we have to being in our head? That's one of the things I think in the near future we're going to deal with. Whether or not at some point, for national security reasons, we can get into somebody's head and find out what they're thinking about, we won't have to deal with for a while, thank God. But I'm assuming future generations will. Okay, I've talked a lot tonight. I had a lot of information I wanted to get out to you. Hopefully, are there any questions that you might, we've got just a couple minutes left here, we're going to take a break. Are there any questions on your part that, or comments that you wanted to bring out, and see what you get, Mark? I'll give
Bob,
you a few.
there's been a couple of folks on the chat stream that have proposed that the way the NSA operates with this open-endedness is analogous to the general warrants back in the 18th century.
Yeah, I think I said that, didn't I?
Right. And so a part of me thinks that they're not, because I might make I don't know whether I believe this, but I think you could make the argument that in the 18th century, there was a rationale for general warrants. There was a legal rationale, and I would say that there was a practical rationale. The practical rationale, going through the legal hoops in a colonial world when you're across the ocean, all of that. And then the legal rationale is colonials were seen as second-class people. They were defined as they weren't defined as in the realm. They were defined as dominion status. So therefore, their legal status was a little bit different. So I think now I'm not saying that's a great rationale for the British, but they had a rationale why general warrants were appropriate.
Right.
Now, whether that, if you can fast forward any of that logic to the modern age, I have my suspicions because the speed at which things happen.
Well, that's the practical end of it, right?
Right.
The philosophical end of it is, are we all just second-class citizens today? Because, you know, this is kind of acting like a general warrant. I think we kind of give our consensus to this. I mean, I don't see any people at the State House protesting this. You know, we just kind of live our lives and go, well, I guess that's okay. You know, I mean, it's not, you know, I don't have anything to hide. So, you know, go ahead. So, Chris, you want to jump in?
Yeah, just a couple things. I'll go back to Thomas Hobbes and the Leviathan. What he says, you know, we don't fear just death. We fear the violent death, right, at the hands of another. So because of that, we're willing to give over our autonomy to an authority to keep us safe. You know, we think flying on an airplane. And so, you know, back to that idea that I've got nothing to hide. So if the government's going to catch bad guys that is going to keep me safe, what do I care about these Fourth Amendment rights?
Right.
So it's interesting to think about that we're going from today's modern idea of the cloud and storage capacity there to Otis and arguing against these general warrants and writs of assistance. I was just going to throw out a scenario that I have not heard it adjudicated yet, but it's fun for students, going back to TLO and reasonable suspicion, right? Let's say now that a teacher has the reasonable suspicion that a kid was using his or her cell phone to cheat on a test, right? And so you turn that kid into the principal, and the principal has the photograph on the phone of the test that the kid took, right? Cheating. And so the teacher has reasonable suspicion that there could be other pictures of tests on the phone, and scrolls through the phone and finds photographs of other illegal activity. Is that admissible using the TLO doctrine?
Yeah.
I don't know the answer. I just like to
it's a great script. I think it's a great scripted trial, Tommy. We need to write, you know.
Yeah.
I love that modernization of it, you know, and what, you know, how private is private.
Yeah.
Tim,
go ahead, Tommy.
If we could go back, because I want people to kind of get the full picture here. Yeah, sure, there were justifications for the general warrant that the Crown used, and maybe even some colonists went along with, right? But you could also point us to specific examples where the use of the general warrant was used in a kind of nefarious ways, right?
Sure.
I mean, you know, that part of the problem was the length of the warrant, right? Because once it was issued, it lasted for the entire time the king.
Life of the king, and I think 6 months afterwards.
Until 6 months afterwards, yeah. And they were kind of fishing expeditions, right, Bobby? I mean, they could. There was.
Hence the name general warrant. They weren't specific warrants, right?
And that's the reason why in the Fourth Amendment we say you have to identify the particular things that you're looking for.
Right.
I just thought, Leming, that was a great overview of the Fourth Amendment, mostly because it followed almost exactly, ironically, a little article I wrote 2 years ago. I don't know if you have. I'm not accused of anything, but no, it was really good.
I think, Tommy, the answer is we both had the same teacher. Okay?
Yeah, that's true. That's true. That's
All right.
true.
Okay, folks, was there something that also popped up, Mark? I know it's 7:58.
Well, can I just say one more thing, too, in terms of the Fourth Amendment? We talk about the right to privacy and, the debate whether or not there is a right to privacy. And I know, Bob, like you said, we didn't have a chance to get into Griswold, but Tim, being the person, the historian that you are, but the idea that these guys probably would have not have, the framers of Madison himself would have not have used the word privacy. The word privy, would refer to your bathroom behavior at the time, perhaps, going to the privy or the outhouse. They would use the word security in the Fourth Amendment, again, to be secured in one person's house's papers and effects. So the debate whether or not there's an actual right to privacy in the Constitution, I think there is a strong argument to be made that yes, you can find it in the Fourth Amendment.
But Chris, that's a great point. And the whole other privacy thing is terribly important. The 14th Amendment substantive.
Stay tuned to Constitution 201.
That's 201. But before we leave, can I beg Robbie could you unmute yourself? You've talked about citizen juries a couple of times and their connection to the Fourth Amendment. That's terribly interesting to me, and I don't quite understand your point. Would you feel comfortable talking about that a little bit?
Yeah, absolutely. So the way that I approach the Fourth Amendment, I honestly think that we as citizens and the court has skewed the interpretation of the Fourth Amendment as the founders may have interpreted that. I honestly can't imagine an oath of affirmation in 1791 being signed over to a judge. That seems totally out of the realm of any founder's line of thinking. I honestly think, if you read through the rest of the amendments and the importance of juries in the Fourth Amendment, and then through the Fifth and Sixth and the Seventh, I think there's a connection there that you can actually connect the Fourth to that. And that an oath of affirmation, not necessarily that the police would have had to go to a jury and get a search warrant prior to searching, but it would have been more along the lines of if a search was unreasonable, then that should be left up to a trial jury of citizens to determine at the back end of that, if that makes sense. Rather, that's what I meant about, I don't think the Fourth Amendment was ever intended to be enforced on the front end of a search. I think it was meant to be enforced on the back end by a citizen jury.
And not by judges, but by a jury. That's correct. Terribly interesting. And if you'll indulge just 30 seconds of Tim to respond to that. I think that's awesome, Robbie. That's great constitutional thinking. Tim.
Well, I'm going to recommend that in the future you just have Robbie as one of the teachers.
No kidding. That was really, really good. I'm not sure.
Robbie's exactly
true, but I'm buying it,
exactly
Robbie.
right.
Yeah.
The founders were more interested in fact, Tom and I were going back and forth a little bit about front end issues versus back end issues, and I think Robbie's on to exactly what the founders were thinking. They were more interested in back end trial sorting out the problems rather than front end issues as it relates to courts' activities on the front end of things. So I think Robbie's point is not only well thought out, but it's actually based in history. So,
and we haven't sort of operationalized it that way.
Right.
Right. We've relied on the court to say this is a good activity or not a good activity.
And Robbie, I think we teach all the time. A lot of us are teachers on this. And we teach all the time about an independent judiciary and how important that is, and that's part of the role of an independent judiciary is to give warrants and so forth, and that's what the founders intended. But I think that Robbie's onto something here, and it's been confirmed by Timmy that. But there we have the language in the Fourth Amendment, though. I mean, you can't get around that, can you, Robbie?
As Right. Yeah. Like what do you mean by
Well,
can't get it?
I mean, even, you're making the case that they were more worried about, back end stuff, but we have clear language in the Fourth Amendment that seems to me to be specifically front end stuff, right?
Mm.
That
But it wouldn't have to be a judge that issued the warrant. I mean, there's nothing in the text that says it has to be a judicial entity.
I get you.
No,
Right.
I guess the point, a general point I wanted to make was, instead of saying a judge, a third party, whether that party is a judge, a jury, or it's somebody else making a decision.
Right.
You can't judge your own case in a sense. You've got to.
But so Timmy and Robbie, are you saying that the Fourth Amendment could be interpreted as only a back end vehicle? In other words, let the cops do whatever they want, let the government do whatever it wants to, and we'll figure it out on the back end,
At the
whether
trial?
it's a jury or whatever. I don't know. I don't think I can get that. I can't get there with you with that reading.
Listen,
But you're also
I
you're
really
also
appreciate
assuming,
this.
Tom, you're assuming a very Americanized assumption that you have rights. British colonials do not have. I mean, I hate to get all eggheady here on this, but the legal status of a colonial is not you're thinking about it in a way that's not British colonial legal status
Yeah, but
way.
doesn't that
Well,
change
I'm
the
not a
Fourth
British colonial, Timmy.
Right.
Exactly, Chris. Listen, I got to call this. This is fun. It's 8:05. This is
Robbie's dying, Bob. Give Robbie the last word.
Well, we can take a break, but we can chat for 2 more minutes here if I'm okay to do that but we can take a break if you want to do that first.
Give us your last thoughts here, Robbie. Go ahead.
Well, I just in response there, I think saying, let the police do whatever they want and we'll figure it out on the back end, I think that's a little too radical what I'm looking at. The language still does state that the right of the people to be secure shall not be infringed and that you have to have a warrant. And so I think that right is clearly defined. But I also, so when a police officer shows up to your house, they still need a warrant. Then they still need to specifically say what they're going to take, what they're going to search for. It's just that if you feel that your rights have been violated, then I would argue that needs to be decided on the back end by that jury through the process of a grand jury trial. Right. I don't think it necessarily, the way I'm looking at it, I don't think it necessarily changes the language, but I think that we have put a lot of emphasis on the front end aspect of it as opposed to giving peers, a jury of peers, the ability to weed that out.
Excellent. That's it, Bobby.
Okay, guys, let's take a 5-minute break, and then Chris, you're up with the First Amendment, which, as everybody knows, is huge.
Huge, Jerry, huge.
Welcome back, everybody. It's now my pleasure to introduce to you Chris Cavanaugh. I've known Chris for, 25 years.
Something like that.
He is a retired teacher from Indiana now. He's at Plainfield High School, but he's in North Dakota teaching up there, which I wanted to have some discussions with him about the difference in the kids from suburban Indianapolis to many of them living on reservations, as I suspect, in North Dakota. So anyway, without further ado, Chris is going to deal with the First Amendment.
Thanks, Bob. Yeah, it's been about 25 years. It's been some time. And I do have some kids, Native American kids I did not have in central Indiana. So that has been enlightening and challenging in both regards. Boy, gosh, it just seems like, I know we could keep going on the Fourth Amendment because it's so fascinating, the case law and the scenarios created, and going. And I always like to think about going from James Otis to the cloud. From this arguing for our rights to be left alone to where we are today, to want to be secure and protected from people that want to do us harm. So it's a great topic, and I find that students are very enthralled with the idea of Fourth Amendment. You know, where does the government get the power to make me pee in a cup, right? That kind of thing. But sorry, we're not going to do that. But I'm going to start with something that's very, very pertains both to the topic that Bob was discussing and the topic that we want to try and tackle today. And I'm going to start with a quote from James Madison. He wrote a letter to Thomas Jefferson in October 1788. And I always have my students try to memorize this quote, because I start my class, one of my classes, I would come in, my We the People class, and I would simply draw a line on the board. And I would ask my students, what is that? And, you know, they know that it's okay to be kind of snarky. So I got snarky answers. And I'll tell you where I get that idea from this quote. Madison wrote to Jefferson that he said, it's a melancholy reflection that our rights be equally exposed to danger, whether the government have too much or too little power, and that the line that divides it is so inaccurately defined by experience. I just love that. I'm going to say that again. It's a melancholy reflection that our rights be exposed to danger, whether the government have too much or too little power, and that the line that divides it is so inaccurately defined by experience. That, I tell my students, is the line. That's the line, right? And if you want to think about it for a second, go back to Jefferson's sentence in the Declaration of Independence, that you know, what I think Kaminsky's called the most important sentence in the history of mankind. Of course, it's a run-on sentence, but it's the sentence that ends in the Declaration of Independence: safety and happiness. And safety and happiness, the and is the line. Because safety, we rely on the government to keep us safe. We want to be secure, so we give the government power. We give the government power to keep us safe. Back to that point I made about Thomas Hobbes, right? What do we fear? The violent death at the hands of another. So we give the government power to keep us safe. Does that mean, you know, tapping our phones? Does that mean reading our email? I don't know, right? But we also want to be happy. We obtain our happiness through exercising our rights. And how far do we get to exercise our rights? And this is what Madison was saying, that we don't know, and that experiences, things are going to happen. We may suffer a terrible terrorist attack like 9/11. We may suffer other calamities that we will want to give the government power in order to keep us safe. But when we get further removed from these calamities and these terrible things, does the pendulum swing back and our rights become restored? That becomes the question, and that is no different in dealing with the First Amendment. So that's what we want to deal with this evening. And I appreciate the fact that Bob started out with Madison's proposals to Congress, or actually that's what Congress will approve. Madison had a much longer list that he's going to give them, and Congress actually approves a part of that list and sends that out to the states for ratification. And by the way, the young man who got the 27th Amendment ratified, which was the one about pay raises, he originally had received a C from his professor on his paper, and he took it upon himself, because of that poor grade, to get the amendment ratified. And they since then, and since the amendment was ratified, they brought the professor out of retirement, and she ceremoniously changed his grade, because he ended up getting an A on his paper, which I thought was awesome. So Mark, if you would, I need to go to the second document on my list of things here. Let me close this out here. Yes, and this again, you know, far be it from me, but I'm using the book again tonight, and this is lesson 29 right out of the book, and it's a great lesson. You know, how does the First Amendment protect free expression? And obviously, the First Amendment deals with a number of rights. And this is not originally what Madison proposed, and he has some editors, we'll call them Congress, and Congress kind of mashes these things together in what we know to be the First Amendment today. And going back to what Bob had said originally, you know, the first words of the First Amendment, Congress shall make no law. And, you know, this is why it's important to think sometimes of these rights in the entire Bill of Rights as negative rights. These aren't saying that I have a right to this or you have a right to that. It's saying Congress can't do these things. And we know, since we've talked about incorporation, that has been extended to the states. And we may talk about that in a second when we talk about the First Amendment and freedom of speech, because that is the point of this evening, is the idea of Congress shall make no law. And you can see here, abridging the freedom of speech or of the press, of the right of the people to peacefully assemble and petition the government for redress of grievances. That takes out the free exercise clause, as well as the establishment clauses that deal with religion. And my goodness, we simply just don't even have enough time to even do that. So these are considered political rights, right? These liberties are, I always like to use the term liberty too, control of freedom. These liberties are considered political rights. These are going to allow you and me to participate in the political process. But where does the government draw the line? At what point does your speech, expression, press, or whatever, where does it go too far? And this becomes a very difficult thing to determine. And much like going back to looking at search and seizure, we have a whole history of case law, and that line constantly gets redrawn. Mark, if you would scroll down for a second, please. There, thank you. What issues underlie debates over free expression? Now, just to cut to the chase, all speech is not spoken, right? All speech is not spoken. There is symbolic speech. Carrying a sign. The sign doesn't say anything. Bob mentioned Tinker earlier this evening, wearing a black armband. The students, Tinker and this other young man, the two Tinker children and the other young man, didn't say anything. They simply wore a black armband to protest the Vietnam War, right? Burning a flag, you're not saying anything, but that the court has determined that that is expression. So we're gonna jump into the breakout room here in just a second, Mark, but I just want to read this with you guys. Sometimes expression is unfairly critical and downright offensive. The press can publish politically sensitive and even misleading information that angers public officials and makes it difficult for people to make informed decisions. My goodness, I mean, all you have to do is be paying attention to current events right now. I think you have a basic understanding of that, right? Free expression can undermine people's privacy and harm their reputations. It is not easy for people to tolerate expressions for those with whom they strongly disagree. A warning case I would throw out right here might be Snyder versus Phelps. We have a group of people in the Westboro Baptist Church who are famously protesting at soldiers' funerals, carrying signs. And you know, I want to apologize in advance if I throw some things out here that may be offensive, but this stuff has all been adjudicated by the Supreme Court. The members of the Westboro Baptist Church were carrying signs like, God hates fags, and that's why your son died, because America loves fags. And they were protesting at the funerals of soldiers. And if you think about what it says here, it's like many people would just consider that reprehensible. Now, how is that allowed, right? And the court was forced to rule on that case. Nonetheless, the right to think and make decisions about morality, politics, or anything else is part of individual liberty. And I think this is what Tommy was talking about last week. You know, I as an individual should have the liberty to be able to do this. Where does the government have the right to tell me I can't? And the British philosopher John Stuart Mill, who is an incredible person to read in this regard, argued that progress is possible only when all points of view can be expressed and considered. The robust debate that results from free expression helps to expose weak, faulty proposals and arguments. People can participate intelligently in public affairs only if they have the information, ideas, and different points of view. Free expression also makes it possible to expose infringements of rights. So if you would scroll down just a little bit, Mark, and this is, thank you, we're just going to get to the what do you think, right? And this is where we're going to go to breakout rooms, because we might as well get started with your thoughts. Individual rights, such as the right to free speech, can conflict with the public interest. Which branch of government, legislative, executive, or judicial, is in the best position to identify the public interest and thus determine how to balance individual rights against the public interest? So again, we're talking about Madison's line. Who gets to draw it? Who's best in position to draw it? Is this the legislative branch? Is this the executive branch? Or, kind of going back to our previous discussion, are we going to allow it on the back end with the courts, right? So I want you to get into your breakout rooms, discuss this, pick someone to report out, and then we'll come back in about no more than 7 or 8 minutes, Mark. So Mark, who had group one? Unmute yourself, Mark. You're the bus driver. Come on.
That's a good point. Thank you for pointing that out. Group one was Tom Bonds.
Okay, I don't know how to say this, but group one's going to provide an answer that is going to be the best, and the other groups aren't going to want to say theirs. So,
should we save you guys for last?
You could if you wanted to, but I really want to say it now,
okay.
if I could. So, when it comes to interpreting, where our rights end and where public interest, a public interest of a sufficient magnitude begins, we have historically relied on the courts, or at least most of the time, average people think that the courts are the ones that establish those endpoints. And in fact, that's true. And one of the reasons why Bob Leming and I have used, and a lot of you teachers have used Supreme Court cases to teach constitutional issues, because they involve the real lives of citizens, and they also involve, by definition, constitutional controversy, and oftentimes they set the endpoints. However, we're not, group one, if I could be so bold, is not willing to give all of the responsibility for interpreting what's in the common good and what are where our individual rights end to the courts. Rather, Tim, you'll like this name, we agree with Walter Murphy. And Walter Murphy is a really famous, I don't even know if he's still alive, but I like almost everything the guy ever wrote. By the way, Bobby, he was Will Harris's main mentor at Penn. And anyway, Murphy makes the point that we are all interpreters of the Constitution. It's not just the Supreme Court, but it's also the president. It's also members of Congress. It's also state governors and state legislators. It's also police and anyone else that works for the government. And it's also average citizens. And so even after the court has done, okay, that's my supper frying. Sorry if you can't hear me. Even if you disagree with the Supreme Court, that doesn't mean, it means that we have to follow that decision, but it doesn't mean that we have to agree with the Supreme Court, right? And so we can still be interpreters of the Constitution, and we can still say as citizens, you got that wrong. Thank God there were people that said Plessy versus Ferguson was wrong. Thank God there were people that said Buck versus Bell was wrong, and on it goes. And so we like the idea that we're all interpreters of the Constitution. We all get to decide as citizens where our rights end, and there's a governmental interest of sufficient magnitude to limit those rights. And again, I challenge groups 2 and 3 to a better response.
Well, group 2 is Tim Moore.
I know he's not going to do it.
No?
Okay, maybe he'll do it.
Well, we're going to unleash Tara Lisa on you, Tommy.
Okay. Tara Lisa, you are unmuted.
Hey, by the way, Tara Lisa. Tara Lisa.
Not a nice statement.
By the way, Tara Lisa, you had a great question before we went into groups that I want to come back around to if we have time.
Thank you. Group 2 is very common, our response, and that some people may call us middle of the roaders, that we did not decide either way, but we felt that neither the government, the courts, our representatives could all hold our decisions. And then we even broke it down to the state level and felt that there is a certain degree of upholding our rights, but then and public interest, but then heads can be turned and folks can be swayed by money and other promises. and it's not always a commitment to what the people want or are concerned about. So we felt that no one group holds the ability to really interpret and extend the rights of the people.
So basically, it was you basically agreed with Group 1. So I guess
Yes,
we're
we
talking.
are. We just didn't have all the great people and statements and cases that
Yeah,
you have to back it up.
And it only took her 3 minutes to say it.
Ooh.
Wow.
That was nice. You guys are wild.
I deserve that. I deserve that. Go on.
But I think the challenge for us is that even we were talking about New Jersey's case of marijuana legalization and the push of the public interest, whereas I believe it's Michigan, one of our group, they voted for it, but when it got back into the courts, quote unquote, and the legislators began to work with it, they began to move away from what the public had actually put into play and began to change it for their own interest, which is very upsetting because the people spoke and then, legislators made the changes and it started turning into something that the people did not want. So
Right.
it's a good issue.
Yes, it's an interesting issue when people speak and lawmakers or courts.
Lawmakers thing, yeah.
Yes. Yeah, we see the same thing coming out of Florida, obviously, now when the people of Florida voted to restore voting rights for convicted felons or former felons. And now we see the state legislature trying to go back and change that for sure. Right. Group 3, we nominated the youngest among us to speak, and that is Robbie. So Robbie's our spokesmodel.
All right, we're gonna stir the pot even more here. I think listening to the explanations from the past two groups, this is my own thought precursing Group 3's thoughts. So the reflections of Robbie don't necessarily match the reflections of Group 3. I think in these discussions too, we have to be careful with our discussion of the people, because I think we are kind of objectively lumping everybody into the same category. And by doing that, when you say things like the people agreed, I think we are still missing that. I can't think of many other, maybe other than the election of George Washington, of many other things where all the people were completely in agreement for something. So I think that's why Group 3, now getting on to our actual discussions, Group 3, we originally started talking with the legislative branch, and then our discussions kind of turned away from that because we mentioned that our rights, especially specifically like the First Amendment rights, freedom of speech, they're specifically minority rights. They're meant to protect minority groups from the large overarching faction of the majority. And so we felt that the best branch to protect that was, in fact, an independent judiciary. And an independent judiciary, though, as we mentioned, looks undemocratic and is theoretically undemocratic, it is the best force to ensure that rights are being protected. Though imperfect, I think of the three, Group 3 was in agreement that the judicial branch was the best.
Okay.
Professor Moore, did you want to unmute yourself and say something, or were you just having a seizure?
Well, we talked a little bit about short-term public interest or long-term public interest. And I think if it was maybe Lisa or Kim in our group had pointed out that obviously legislatures occasionally get something wrong, and down the road of history, we go, oops, bad one. So maybe we thought maybe there's a short-term public interest issue versus long-term public interest that the courts are more, arguably more in tune with. So,
yeah, I think too, when you think of the courts, I think I'm going back to our previous discussion that they do provide more of a back-end check, right? Because we don't know where they're going to draw that line until someone obviously challenges that, right? As you know, again, we haven't really got into this discussion, but the courts, it must be a case or controversy. I mean, the Constitution says that. And for the Supreme Court to be able to take the case and hear the case, you have to have the rule of four justices must agree. And so it takes a while for those things to work their way through the system. And I got to say this too, I do really appreciate the fact that a number of you guys are really thinking about state courts as well and what happens at the state level. I think it's so easy to get lost in our discussions of the Constitution at the national level or the federal level. I do appreciate the fact that you guys are thinking about what happens at the local level, right? So that's really good stuff. I do want to, I mentioned this in our group thing, and I want to go to a decision in 1943. Is West Virginia versus Barnett from Justice Robert Jackson. This is one of the flag salute cases. This is where the court will reverse itself from an earlier opinion in 1940, the Gobitis decision, the idea that Jehovah's Witnesses were being compelled to stand and say the Pledge of Allegiance. And in Justice Jackson's opinion in 1943, there's some language that I have in my handy dandy pocket constitution that I don't leave home without, and it's the whole idea of the rights are, there's some rights that do not belong on depend on the outcome of any elections, right? That these rights, and I'm just going to, pardon me if I read along here. If there's any fixed star in our constitutional constellation, is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. If there are any circumstances which permit an exception, they do not occur to us. So very, very powerful opinion in terms of the idea that our rights don't depend on the outcome of elections and the popular wills of majority, and maybe going back to what Tim had mentioned in terms of that short term. Mark, if you could go back to my documents and go to the very first document, we're gonna have to fly through this simply because of time constraints. Yeah, the first document, freedom of speech. Let me move you folks over so I can see this. And this is a document that I put together for a class in terms of looking at some case law and as well as tests that the court will use for determining when to put limits and when not to put limits. In the first two cases we see here are Schenck 1919 and Abrams 1919. And it's very interesting because if you look at Schenck, it's 9-0. And if you look at Abrams, it's 5-4. And there are several things amazing about this case. It's coming out of World War I. Congress had passed something called the Espionage Act, and they'll follow that up with the Sedition Act. And it's amazing if you go back and look at the history, what people would say an offhand comment on the train about not supporting World War I, and the next thing you know, they're getting in trouble for these things. But Schenck gives us the opinion from Oliver Wendell Holmes, and he is key here. Holmes is very key when talking about freedom of speech, because in Schenck, he comes up with the concept of a clear and present danger. If your speech presents a clear and present danger, then the government has the ability to regulate that. He gives the famous line about shouting fire in a crowded theater. You don't have that right because that speech puts people at risk, your individual right versus the common good. And if you look at that case, it's 9-0, and the court had no problem with limiting what happens here with Schenck and the pamphlets he was putting out that were contrary to supporting World War I. But if you look at Abrams and you see there's a bad tendency test, and you can read that for yourself about it deriving from English common law, and do these words, have a tendency to bring about something evil. But what's amazing about this case is it's somewhat the same argument, but Holmes writes a dissent. He changes from Schenck writing the majority opinion to what he writes in his dissent. And the one line there where it says in his dissent, Holmes argued, right? There's so much more. And in Holmes's dissent in Abrams, considered one of the most powerful dissents, he talks about the idea of the market, well, he doesn't call it this, but we call it this now, the marketplace of ideas. And he's willing to let the marketplace of ideas and the truth of an argument determine whether or not that argument should prevail. The government should not limit this. He is influenced by a scholar named Zachariah Chaffee, who writes a law review article for the Harvard Law Review which is very influential. He's influenced by a judge named Learned Hand, who's in the textbook. He's in one of the preliminary exercises in the We the People textbook, Learned Hand. He's influenced by a couple of other folks, and he changes from his majority opinion in Schenck to writing this powerful dissent in Abrams about the marketplace of ideas. And he's joined by a guy that Robert had mentioned earlier, Brandeis. Louis Brandeis is the first Jewish member of the Supreme Court. And if you scroll down a little bit to Whitney v. California, there's Whitney v. California. You have the preferred freedoms doctrine, and you can read this on your own, but I would really, really encourage you to go read Brandeis's concurrence. Brandeis writes a concurrence in this case, and he's joined in this by Holmes, and is perhaps one of the strongest arguments supporting the freedom of speech. It almost reads like a dissent, but it's Brandeis concurs with the majority in this case about the anti-syndicalism laws in California. It's about supporting communism. It's amazing how far we've come in extending freedom of speech. But I would encourage you to go on to read Brandeis's concurrence in this, because there is, oh my goodness, it's such strong language. For sake of, and I hate to do this, we got to fast forward. If you would scroll all the way down for me, please, Mark. There should be a chart that we're going to get to. There we go. And this is just to draw your attention to this. These are the legal standards that's determined by the court. And you can see starting with excuse me, in Schenck, the clear and present danger doctrine. And then you get Abrams, you have the bad tendency test, preferred freedoms, and it gives you the justices that wrote these opinions and the case from which they come, and getting down to clear and probable danger. And Vincent, if you would scroll down just a little bit more, I believe. Is that it? Oh, okay. There's one other case too, is Brandenburg versus Ohio. This kind of where we left off here. Brandenburg versus Ohio was a Klansman that was giving a speech, and the court is going to move away from the clear and present danger and bad tendency tests, and they're going to talk about your speech can be limited if the threat is imminent. So if you're, I always tell my students, I could go out on the street corner right now and say, go get your guns. The governor is a tyrant. We need to march down to the State House and overthrow him. That speech is protected because the threat is not imminent. I'm just going to be the crazy old guy out on the corner howling at the rain, and no one's, people are going to drive by me and maybe drop off some money because they feel sorry for me. But if I was speaking at a rally, and I was speaking perhaps at a rally of people, pro-Second Amendment folks that are heavily armed, and I get them agitated to go out and shoot the police because the police are, jackbooted thugs, and my speech is really over the top. That speech could be limited because the threat is imminent. It's going to happen. And that comes out of Brandenburg versus Ohio, which is a case to take a look at. And again, I keep looking at my watch because I realize I have like 3.5 minutes left, which is, it's not nearly enough time to really dive into some of these issues that take place. And I would just direct you to a couple of the other.
Chris,
yes.
Give yourself 5 more minutes or so, because I took up some of your time, and if people want to leave, they're free to leave. It's a free country,
Sure.
so keep going for a while.
And I'm going to put my PayPal account on here too, so you guys can make sure you get on there. That's a joke. So we haven't even touched on like student speech. I know Bob mentioned the idea of student search and seizure. Student speech, I've got a couple of PowerPoints listed under my section here for what happens with students in terms of student speech. Obviously, we start with the grandfather of the cases, Tinker versus Des Moines, and the idea that not all speech is spoken to these students wearing black armbands in protest of the Vietnam War, and the court will agree with the students that students and teachers don't shed their constitutional rights at the schoolhouse door. But for those of us in education now, we understand that that's really kind of what the students have been doing since then. You end up with Bethel v. Frazier. The school was able to limit a student's speech that was full of innuendo, sexual innuendo, even though he actually didn't use any, quote, dirty words. Then, of course, we get into the Bong His for Jesus case, Morris v. Frederick, or a young man waiting for the Olympic torch to come by his school, and he and some classmates unrolled this 14-foot banner that said Bong His for Jesus. Well, what in the heck does that mean, right? You know, get high with Jesus, get high on Jesus, who knows? But the court ruled that the government was able to limit that speech, and that was not conducive to the educational atmosphere that the government wanted the schools to be able to promote. Actually, someone pointed this out to me. It's really not what the banner said, Bong His for Jesus, Morris v. Frederick. It's what the assistant principal saw when she saw the banner. It's how she interpreted the banner, which really is kind of what we can say about all speech, how we interpret the banner. But I would draw you back to what I said earlier, starting with a quote from Madison. You know, we have these rights, and it is a melancholy reflection that our rights be exposed to danger whether the government have too much or too little power, and the line that divides it is so inaccurately defined by experience. Where does the government draw the line? What do I get to say? How do I get to criticize the government? How do I get to exercise these, what the framers would consider political rights that allow me to participate in the political process? And what is too far? So again, we're doing kind of a short shrift to the First Amendment and freedom of speech, but I would encourage any questions or any other comments you guys may have.
Chris, I'd like to jump in just for a second.
Sure.
Maybe put a cap on this. Free speech, free expression is about speech that we abhor, not speech that we like. It's easy to protect speech that we like. It's tough to protect speech that we might disagree with or think is abhorrent to us because somebody said it.
Bob?
Yes.
Sorry, and then you're channeling Justice Holmes here, because in one of his powerful opinions, it's not freedom for the thought that we agree with, it's freedom for the thought that we hate.
Yeah, I just said it better than Holmes, that's all. Thanks, Chris, for pointing that out. I mean, obviously, I think Holmes is brilliant with this. But I mean, when we think about it on terms about how it impacts our lives, what I'm worried about today is not so much government interference with speech, but us, the people, as Robbie said, some people, I'll say, trying to limit speech because they don't like it. They think it's objective. They say things like that your speech hurts me, physically pains me, or whatever. And that's coming from our citizens, some of them, not all of them. And what do we do about that? When we start putting our own restrictions on speech because it becomes the popular way to go about it, or because we acknowledge it as being, or think it's harmful in some way and physically abhorrent to me, not just mentally abhorrent. There is another whole issue and you know, one example that we could have obviously, Chris, talked about for a long time are speech codes on college campuses, and why the court has thrown them out. Because people are offended by certain words being used on college campuses, and therefore they think the answer is, let's just get rid of those words. Well, I'm a little worried, and maybe it's because I'm an old guy, is what's happening now with some people to kind of try to limit our speech because it's unpopular speech. And that kind of scares me.
Yes.
And the last thing I'll say, and I'll turn it back over to you, Chris, is we spend a lot of time on court cases, and there's a reason why we do that. And I think it's important for all of us to use them. I say court cases are buoys in a sea of madness. Right? They kind of help us. We bang off of them. They guide us this channel to that channel. Here's how do we kind of think about these situations or these ideas today. They don't, in fact, tether us totally. You can disagree with court cases, as Tommy has said, but they give us some kind of way to think through this a little bit. And on the other end of it, it's maddening to a certain degree. about what is acceptable in terms of rights and what aren't. And I'll leave it at that. Chris, you want to finish up?
Just, I mean, I wonder what James Madison et al. Would have to say if you had to try to explain to them, is if the president blocks me on Twitter, is that a First Amendment violation? And you know, and that's a question that has been raised. So, you know, going back even what you said about in terms of speech codes on college campuses and people needing safe spaces, and we didn't even get into the concept of hate speech.
Right.
But, you know, so the whole idea of, you know, how far do we go and where the line is drawn? And I love your analogy, Robert, about these Supreme Court decisions being buoys which we can cling on to in a sea of madness. I think that's pretty appropriate. So I'll leave it at that.
Well, thank you all again. Week 6, can you believe it, is coming up next week. And you know, as you noticed tonight, we certainly did give Chris the right amount of time to deal with the First Amendment, and we'll talk about that for future reference. Look forward to seeing you all next week. Next week is going to be Unit 6. I'm going to deal a little bit with the civil rights movement as a part of history that I think is important for Americans to know about and to think about in terms of what our role is as citizens and what we can do. Remember, I started off week 1 with the idea that here's government. It has to be in our hearts and our minds, but what happens when it breaks down? People got to take it to the streets. And how do they do that in an effective manner? That's what we're going to talk about in the first hour. Then Tommy's going to get into returning to fundamental principles. I love that phrase. And the ideas of some of the things that we talked about in week 1 and wrapping that up with our responsibility as citizens. What do we do with this information? You know, it's great that we have it, but how active are we supposed to be, and when do we go into action? Those are things I think we want to talk about next on Unit 6, week 6. So have a great weekend, and we'll see you next week for the last session. I guess I'm kind of sorry to say about that. Bye-bye.